Hey, this is Angela, and you're listening to the Study for the Bar in Your Car podcast. In this podcast, we will be going over defenses to contracts and contract enforceability. Anyhow, so you know how it works. In this podcast, it is a podcast within a podcast. So I'm Angela. I'm a law student. I've taken all the notes that I've taken from law school and also from my bar study, all the outlines I've created. I've put them into AI, and I've had AI generate this podcast. So you'll hear a male voice and a female voice. I've nicknamed them Maud and Claude, and they just talk about my notes. So I'm not a lawyer. I'm not barred by any state. I am barred by 2 Native American tribes, and I will tell that information in some other episode. But this is to say, I'm not giving you legal advice. Also, AI isn't always correct. And I'd like to think my notes are on point and correct. Occasionally there's something that's like not right, but I really, really try to go back and fix something that isn't correct. And when something isn't correct, what it means is that I need to go back to the podcast and readjust my notes and then regenerate that podcast. So these podcasts with Maud and Claude are auto-generated. I use this software it's a free Google software, so anyone really could do this. And I'm surprised no one has done this before me. The software is called Notebook LM. And I just put my bar notes in it and then have it generate a podcast. And this is the result. So without further ado, here is Maud and Claude. And we're going to dive deep into contract enforceability and the defenses.
Welcome to this deep dive into contract law. We're using Angela's fantastic notes to get you ready for the bar exam.
That's right.
Today, we're hitting a really crucial area, defenses to contract enforceability. Basically, when can someone argue a contract shouldn't hold up?
Exactly. And Angela's outlines give us a great map through this. We're talking about everything from whether someone even had the capacity to make a deal, all the way through things like pressure, mistakes, even outright lies, illegality, and that big one, the statute of frauds.
So our goal today is to take these concepts from Angela's notes and make them really clear, really practical for tackling those bar exam questions.
Yeah, let's break it down. Angela's hard work is going to be super helpful here.
All right, let's get into it. First up, based on Angela's materials, is the idea of lacking capacity to contract. Where do we start there?
Well, Angela's notes logically start with minors, or infants as the law sometimes calls them. Her outlines are pretty clear. If someone is under 18, generally any contract they enter into is voidable by them.
Okay, so the minor can choose to get out of it.
Right. But the other party, the adult, they can't use the minor's age to back out. It's a protection for the minor. Angela stresses that point.
Makes sense. Protection for those considered not fully mature enough for binding deals. What about mental capacity? Angela covers that too.
She does. And her notes explain that if a person's mental state is such that they just can't understand the nature and consequences of the contract, then the contract is also voidable by that person, maybe when they become lucid or by their legal guardian.
Okay.
And interestingly, Angela points out something similar to minors. Even if they lack capacity, they might still be on the hook for necessaries. Things like food, shelter, medical care.
Ah, so under a quasi-contract idea.
Exactly. Angela notes that similarity. And like you alluded to, if they regain capacity later, they can choose to affirm the contract, make it binding.
Got it. Protecting vulnerability, but still ensuring essentials are covered. Okay, moving on from capacity itself. Angela's notes then get into situations where maybe someone had a capacity, but their agreement wasn't really free. Let's talk duress and undue influence.
Yeah, these are big ones for the bar, and Angela's outlines help distinguish them. Duress, she explains, can be actual physical force someone literally makes you sign. That's rare, but it makes the contract void, completely invalid.
Okay, void, not just voidable.
Right. More common, though, is duress through improper threats. Angela's notes say if you're faced with an improper threat like bodily harm or maybe a bogus lawsuit, and it leaves you with no reasonable alternative but to agree, then the contract is voidable by you, the person who was threatened. The consent wasn't real.
Okay, so serious threats give the victim an out. What about, like, financial pressure? Angela's notes mention that too, don't they?
Yes, and this is the key nuance Angela highlights. Threats to property or finances can be duress, but there are conditions. The threat has to be wrongful.
Wrongful, okay.
Not just hard bargaining. It needs to be serious, and you couldn't reasonably protect yourself otherwise. But, and Angela emphasizes this, just being in a tough financial spot, like facing foreclosure, isn't usually duress on its own, unless the other party wrongfully caused that hardship.
That's a really important distinction. Hardship versus actual wrongful coercion. Okay, so that's duress. What about undue influence? Angela's outlines position this differently, often involving relationships.
Exactly. Undue influence, according to Angela's notes, is about unfair persuasion that overcomes someone's free will. It often happens in two types of situations. One party just dominates the other, or there's a special relationship of trust and confidence that gets abused.
Like an advisor and client.
Precisely. Angela gives a great example. A financial advisor convinces an inexperienced client to sell land way below market value. Because of that trusted relationship, Angela's notes explain, the contract could be voidable due to undue influence. It's about exploiting that trust.
That clarifies how persuasion can cross a line, especially with that power imbalance or trust. Okay, next in Angela's sequence. Mistake and misunderstanding. This feels like an area where things can go wrong, even without bad intentions.
Absolutely. And Angela's outlines cover this well. First, there's mutual mistake. This is when both parties are mistaken about a really fundamental assumption underlying the contract.
Both sides got it wrong.
Yeah, about something basic, and it has a material effect on the deal. Angela's notes say the contract might be voidable by the party who's harmed by the mistake, unless they're considered to have borne the risk of that mistake happening.
Okay, so if the very basis of the deal was flawed because of a shared error, enforcement might be unfair.
That's the idea. Now, what if the parties actually agreed, but the written contract doesn't reflect that agreement accurately?
Like a typo or leaving something out.
Right. Angela calls this mistake in written expression. Her materials explain that if there's a mutual mistake in the writing, a court might reform the contract.
Reform, like rewrite it.
Essentially, yes, rewrite it to match what they actually agreed on. Angela notes this covers things like fixing wrong terms, adding stuff that was left out, or deleting terms that shouldn't have been there.
Okay.
But, there's a catch Angela points out, reformation usually won't happen if it messes up the rights of innocent third parties, like someone who bought the thing in good faith without knowing about the mistake in the original contract.
Makes sense. Fix the error between the original parties, but don't hurt innocent bystanders. All right. Moving from mutual errors to situations where one party might be misled, Angela's notes cover fraud, misrepresentation, and non-disclosure next.
Yep, a really critical area. Angela's outlines spend a good bit of time on affirmative misrepresentation, basically saying something that isn't true.
A lie.
Pretty much. But Angela clarifies that generally, opinions or, like, future predictions don't count. It has to be a misstatement of a present fact. Her example is a franchisor giving bogus financial data to a franchisee. That's a clear misrepresentation.
Okay, stick to the facts. But what if it wasn't an intentional lie? Just inaccurate, but still influential. Angela's notes discuss material misrepresentation, right?
Exactly. Angela's materials explain that even if it wasn't fraudulent, a contract can be voidable if the misrepresentation was material.
And material means?
It means it was likely to influence a reasonable person's decision to agree, or the person making the statement knew it would probably sway the specific person they were talking to.
Okay.
And Angela's notes add that even negligent misrepresentations, saying something false carelessly when you should have known better about a material fact, can also let the other party void the contract.
So intent isn't always required if the false statement was important and relied upon. Now, Angela mainly focuses on what's said, but her notes touch on non-disclosure too, right? What about keeping quiet?
Yeah, while it's not the main focus in this section of her notes, she does acknowledge it. Sometimes, failing to disclose something really crucial can be grounds for a defense.
When would that happen?
Usually if there's a duty to speak up, like in certain relationships, or if the hidden fact fundamentally changes the deal. It's very fact-dependent, as Angela implies, but it's about basic fairness, not letting someone take advantage by hiding key info.
Gotcha. Okay, let's shift gears to another set of defenses Angela covers. Illegality, unconscionability, and public policy. These seem to target the substance or fairness of the deal itself.
That's right. Illegality is pretty straightforward in Angela's notes. If the contract involves illegal conduct, either the performance is illegal, the consideration is illegal, or the whole purpose is illegal. It's generally unenforceable.
Flat out unenforceable.
Generally, yes. Angela emphasizes that courts typically won't help either party enforce an illegal bargain. Anyone involved can usually raise the illegality defense.
Okay, so the law won't back illegal deals. What about deals that aren't technically illegal but just seem really, really unfair? That's unconscionability.
Exactly. Angela's outlines break this down nicely into two parts, procedural and substantive. Procedural is about unfairness in the process of making the contract.
Like hidden terms or unequal bargaining power?
Precisely. Unfair surprise, maybe tiny print, or a huge power imbalance where one side really had no meaningful choice. Substantive unconscionability, on the other hand, looks at the terms themselves. Are they incredibly harsh, totally one-sided, just shocking to the conscience?
So it's about both the process and the result being fundamentally unfair.
Yes. Both are usually needed, though sometimes one might be extreme enough. And then there's the related concept of public policy. Angela mentions this too.
How does that differ?
Well, Angela's notes don't go super deep here, but basically, even if a contract isn't breaking a specific law, courts might refuse to enforce it if it strongly violates some established public policy, something considered bad for society overall. It's a bit of a catch-all for agreements that are just fundamentally against the public good.
Okay, a safety valve for really problematic agreements, right, that covers legality and fairness. Now, for the one that often trips people up, the statute of frauds. How do Angela's notes help us navigate this?
Angela's outlines provide a solid structure. The basic idea, she explains, is that certain kinds of contracts must be in writing and signed by the person you're trying to sue. Otherwise, they're unenforceable.
To prevent fraud on major deals, basically?
That's the historical reason, yeah. Angela highlights the main categories you need to know for the bar. Contracts for selling land. Contracts that literally can't be finished within 1 year.
Okay.
And, under the UCC, contracts for the sale of goods worth $500 or more. Those are the big ones.
$500 or more for goods. That comes up a lot. What does Angela say that the writing needs for those UCC contracts?
Her materials are specific here. The writing needs to show a contract was made, identify the parties, state the quantity of goods.
Quantity is key.
Absolutely essential under the UCC rule Angela describes.
Yeah.
And it needs to be signed by the party being charged, the one trying to get out of it. Interestingly, Angela notes that a signature can be pretty broad under the UCC. Sometimes even a letterhead counts.
Huh, okay. Letterhead. Good tip.
But she also adds a crucial limit. The contract is only enforceable up to the quantity stated in the writing. If you agreed orally on 200 widgets, but the memo only says 100, you can likely only enforce for 100 based on that writing.
Got it. The writing limits the quantity. But there are exceptions, right? Angela's notes mention times when you don't need a writing, even for these contracts.
Yes, definitely. Angela's outlines cover important exceptions. For land contracts, she mentions full performance by the seller, they already transferred the land, or significant part performance by the buyer.
Part performance being?
Usually a combination, like the buyer paid part of the price, took possession, and made improvements, things that strongly suggest a deal existed.
Okay, actions speak louder than words sometimes. What about exceptions for the sale of goods under the UCC?
Angela's notes point to a few key ones. If the goods have been received and accepted by the buyer, the statute is satisfied for those goods. Same if payment has been made and accepted, it makes the contract enforceable for the goods paid for.
So partial performance counts to some extent.
Exactly, to the extent of the performance. And another big one Angela highlights is for specially manufactured goods.
Custom orders.
Right. Goods made specifically for the buyer, not easily sellable to others. If the seller has substantially started making them, or committed to getting them, before the buyer tries to back out, Angela's notes say the contract can be enforced even without a writing.
That makes sense. Protects the seller who made a custom effort. So finally, what if a contract should be in writing under the statute isn't, and no exception applies? What's the result, according to Angela?
Her notes state the contract is then unenforceable at the option of the party being sued. They can use the lack of writing as a defense.
A defense they have to raise.
Yes, Angela emphasizes it's a defense that can be waived if you don't assert it. It doesn't make the contract void automatically, just unenforceable if the defense is properly raised.
Okay, so it's a shield, but you need to pick it up and use it. Whew. Well, that covers a lot of ground on defenses to enforceability. Pulling straight from Angela's detailed notes, we've hit incapacity, duress, undue influence, mistake, misrepresentation, illegality, unconscionability, public policy, and finally tackled the statute of frauds.
Yeah, it's a dense area, but absolutely critical for the bar. And hopefully, walking through Angela's structure helps you see how these pieces fit together. Remember, as you do practice questions, look for the specific facts that might trigger these defenses.
Absolutely. It's about applying these rules. Angela's notes give you that solid foundation. We definitely encourage you to revisit these concepts, maybe dig a little deeper into areas that felt complex, think about other scenarios, how courts might weigh these factors.
Keep asking those what-if questions. It's great preparation.
Exactly. Well, thanks for taking this deep dive with us, powered by Angela's excellent notes. Keep up the great work on your bar prep.
Hey, this is Angela. I'm back, your living, breathing, not AI podcaster. So I hope you enjoyed that on enforceability and defenses. And just so you know, we have a separate episode just on the statute of frauds coming up. I think that might be episode 11. I'm not sure. I have to check back. Anyhow, so the very next episode we're going to get into is like content and meaning. So this is really like parole evidence type stuff. So, yeah, I look forward to seeing you on the next podcast. And if you need to get in contact with me, my email address is podcast@studyforthebarinyourcar.com. I also work as a freelance remote law clerk to attorneys across the world, but mostly in the United States. So if you are an attorney or know an attorney who needs an extra set of hands, someone to do that motion or someone to do that appeal that you just don't have time for, call on me. Hey, I'm a law clerk. You can reach me for legal work at hello@legalwriterandlawclerk.com. All right, we will see you on the next podcast. Bye.